Are we ready?
Before we start
before
any
we,
of this, I want to let you,
What?
our big deadline
Okay.
is next week, and so the changes this time might have been a little bit rough.
okay, all right. Oh, okay, all right. Thank you for that. Let's get a, roll call on the phone. Who's with us there? Ken Sherman, you're with us?
Yes.
Shannon Conley's here.
Sandy?
Oh, Shannon.
Sorry, Shannon, that's you.
Oh, yes, it is. With no baby
Great.
this time. Exciting.
No baby. Are you back at work?
Oh, no, not quite yet, but I am in a room that's isolated.
Okay. All right. Okay, so Ken and Shannon, I'm sorry, so who else?
Clackamas County.
Clackamas County.
The whole county?
Yes, it's a party line.
Hey.
It's a party.
Anybody else?
Sarah Kersley.
Who?
Sarah Kersley.
Sarah. All right. No Cleve Abbey today? I guess not. Okay, let's go ahead and start. What I'm hoping to do today is pretty much get to the point where we are satisfied with the three drafts that we have, LC 8888, 8889, and 2957, so that we can kind of put those aside and then in the next meeting work on whatever changes we see coming in on Chapter 111 and the statutory form, and try and get those crammed in before, well, basically before we run out of time. So let's start with 2957, I guess. This is the non-asset probate, no asset probate. Marissa, do you want to tell us what's different in this one? Let's start with that.
So if you go to page 3, so in 2D, used to have at the end of that, and
Yes.
no assets have come into the possession, and then now 3 is different. If the court has issued the letter, so that.
Okay, so let's look at that. Yeah, we did that because typically the request for a waiver of bond is in the petition, so you don't have that interval of time. That explains the change in D. The petition for appointment of PR states that no assets are known. And 3, this is new, different. If the court issued letters of administration to the personal rep because.
This is a little weird.
Well, yeah.
Yeah, because it's not just that they issued letters at
No.
all. It's if they issued letters because 2 said that 1 didn't apply.
Okay, and also it wouldn't just be letters of administration.
Oh, what,
Right? It
Back
could-
to D.
Yeah.
letters, just letters.
Yes, John.
As provided in ORS 113.035 sub 12 seems wrong.
You mean just grammatically? Because that is the section that,
The first part of that sentence is a statement of fact.
yes, right.
And no facts are provided in any statute. And then you look at sub 12, and I'm not quite sure why you want to, what that has to do with it anyhow.
Well, that's where if the petition states as it says in 12, that no assets are known.
Actually, 11 is where it says no assets are known. Because it says if any. The 12 is where you have to say if there are no assets, then you have to say why or what the purpose is.
I mean, we can just take that out, that's fine.
Yeah, just basically no assets are known to the petitioner.
Yeah.
And we don't need the cross-reference. Yeah. Okay, yep, grammatically, that makes sense. Okay, then let's go on to 3. If the court issued letters.
Just letters.
I think so. Yeah, if the court issued letters to the personal representative because subsection 1 of this section did not apply under 2D, and assets of the estate later come into the possession or knowledge of the PR shall, within 30 days after the filing inventory or supplemental inventory first showing assets, provide a bond to the clerk that complies with this section unless the bond is otherwise not required as provided in this section. It's a little clunky.
It's totally clunky.
But I mean, it works, right? I mean, this is what we're after. I don't think we need to do a lot of wordsmithing as long as we make sure we're not screwing something up. But let's talk about that.
So, Lane?
Yeah.
Don't you need a court order to set the amount of bond?
Well, that complies with this section.
I mean,
The-
yeah, and then under
And
1B,
1B,
the amount set by the court under
right.
this section, so it's just saying you're supposed to do what's already provided in the
Right.
section.
Yeah, that was my intention, that compliance with the section would and basically take you back into sub 1. Well, maybe if that complies, maybe that's too narrow, maybe it should be as provided, yeah, as provided. Yeah, because you're right, as complies sort of directs your focus to the bond.
Right, to the clerk of the court.
Well, yeah, and we're really talking about the whole process. So, provide a bond to the clerk of the court as provided in section 1. Subsection 1, unless the bond is not otherwise required. Or, as
Yeah.
provided in this section.
But
Yeah.
then you've got the waiver and all this
Well,
stuff.
but that's already picked up with, unless the bond is otherwise not required.
Yeah, okay. Provided.
So it's as provided in subsection 1 or just as?
Yeah, I
provided?
think it'll say as provided in subsection 1, because that's the one that sets out the requirements of the bond itself. And then as long as we leave in the language, unless a bond is otherwise not required, then we've picked up all the exceptions.
Well, that's a mouthful, but
It is a mouthful,
it works.
yeah. Like I say, it's clunky, and your editor or you might still find a way to smooth that, but it's the right thing.
I'm gonna have some time next week.
Okay.
To look at this
Okay.
more closely.
But the concept is right on.
Okay, so I have that 12 everywhere through here, but I can take that out.
Yeah, that's a good point. Yeah, we didn't pick that up last week,
Yeah,
the
yeah.
last time.
Okay.
And that language, providing a bond to the clerk of the court, that comes right out of section 1, so we'll leave that.
But can you shorten it to say that within 30 days, they'll comply with the bond requirements of this section?
Well, that doesn't so much shorten it, because you'll have to say, unless a bond is otherwise, huh?
I don't know what his guys think of that.
But, okay, let's move on, because I think we're agreed what, this is right. It's just a matter of smoothing the language to the extent that we can.
All right, now we're gonna
Okay,
go
what's next?
to page 4.
Yeah,
The end of section 3 there. The personal representative shall within 30 days after this is, it said discovering the assets, now it says filing the inventory or supplemental
Right.
inventory.
right.
Okay.
And I think we can also do the same thing as we did before, just take that as provided.
Yeah, I'll
Just-
take all those out.
Yeah, right. Mm-hmm.
Could we go back
Matt.
to, page 3 in that section 3?
What?
Would it clarify this, just say, shall within 30 days file a motion to set bond in accordance with this section? Something like that?
Instead of saying provide a bond to the clerk of the court?
Yeah. I mean, because this kind of gets to Judge Cobb's point, like, there's a process that has to play out here. You've got to tell the court, A, that you need a bond, B, what you think the amount should be, or why, if there's other reasons that you think it should be waived. And then that kind of gives a little more clear direction of.
Well, I was kind of hoping that just
what you should do.
as provided sort of encompasses all that without,
I think he's saying like in the first place, at the top, in 1.
well, it is interesting, if you look at it, subsection B, if you go back to 1A and 1B, subsection B begins with an assumption about A that really it doesn't, it says the amount of the bond set by the court under this subsection
Yeah.
And there's nowhere else that talks about the amount being set by the court.
Right.
That's true.
I mean,
It doesn't. It just
At
says
least it
that
could say,
PR.
provide the bond to the clerk of the court as in an amount ordered set by the court or something,
You
yeah.
can't provide the bond
Without,
without an order. You can't get an order.
without an
within
amount.
30 days,
Huh?
within the 30 days.
But you can file a motion within 30 days.
You do that, and then you lose control.
Okay, well, then we're back to Matt's then, maybe that's what you do.
I think it would help at least to say, provide a bond to the clerk of the court in the amount set by the court or in an amount set by the court.
So John's point is, okay, within 30, you may not be able to file the bond
You can't provide. the
if it
bond.
takes, well, yeah, it depends. So maybe Matt, that might not be a bad idea. It's really weird having your name upside down.
Sorry.
I know they're lightning in Clackamas County, but.
Of course. So maybe that's it.
Try that. What do we want it to say?
Well, we shall file a motion,
And we're gonna do that within 30 days of the, after.
a motion to what? To,
To set or waive bond. I mean, there may be other bases to waive it, I guess, but.
okay, a motion to set or waive the bond as provided in section 1. It was to set or otherwise waive the bond requirement under subsection 1, because 1 includes the exemptions.
And then within 30 days after appointment?
Yeah,
Or after?
no, after the inventory,
Oh,
still.
oh,
Wait, I'm sorry, you're in 1, we're
we're down here.
We're down here.
Oh, I'm not understanding what we're doing.
in 3.
I see what you're saying, okay.
The personal representative shall, within 30 days after
The
filing
whole thing.
the inventory, file a motion with the court to set the bond.
Okay, but yeah, file a motion, okay, yeah.
Because that's what they have to do. We can't, the filing the bond, you're right, requires intervening actions by the court.
Okay, I can make
Okay,
it work by it.
do we want to do anything to 1 to clarify? No, it's worked forever. It's worked forever, right?
Yeah.
Yeah, okay, we'll just
So
not go,
you said that if you find other assets, you will
file a motion.
comply with the bonding requirements of this section.
That just seems vague to me.
And
Yeah, let's say,
file a motion within 30 days in order to do that.
well, I think a motion to set the bond, because that's gonna trigger an order, and the order's gonna say, file your damn bond, and,
The set or waive.
or wet, that's right, yeah. So I think all we need to do is the motion, because everything else will follow from that. File a motion to set or otherwise waive. Okay, that's a good
Well,
point.
do we need something to reinforce the bonding requirements? Because you file a petition that says you got no assets, so that waives
Right,
the bond
Right.
requirements. And then you later find assets, don't we need?
so you file a motion to
Well,
set,
but don't we need something in the statute that says the bond, you've already waived the bond.
right,
So doesn't the statute have to now unwaive the bond?
well, it's telling you to file your motion to set the bond within 30 days.
But nothing's required to bond yet, it's already been waived.
Right, but that goes to the question, we talked about this, where, do somehow the letters become invalid, because now you don't have a bond, but you do have assets, and we didn't want to do that.
So actually, I see your point. So
What?
what if we said, you're gonna comply with the requirements of this section, and then we say, within 30 days, you file a motion to set or waive the bond?
If you think you can do that?
Yeah.
Okay,
So are you deleting the last clause of 3?
we've lost control, Ken, we don't know.
Wait, the last one was
Yeah, Marissa, what have you got in concept there?
Unless the bond is otherwise not required.
Yeah, we've got to leave that, we've got to keep that.
Yeah,
Well, but
basically,
if you, okay,
no, go ahead.
if you said that you're filing a motion to set or waive a bond, I'm just wondering if you need that last clause still. Do you have to file the motion even if, under the rules, a bond will not be required? If you found assets, do you then have to file a motion notwithstanding? And then the court has to go ahead and formally waive the bond at that point?
Well, let's see, under sub two, back of section 1, you've got the waiver, that there's no requirement, if the will says there's no bond, then you'd do that in the first place. You wouldn't rely on no asset. If you had a will that said no bond, you'd have the no bond under that provision, so you wouldn't be relying, well, you've said no assets. So,
That's right, if you open the no asset estate with a will that waives bond, and you later find assets, the waiver should still be
valid.
In these cases in 2, do you actually still go to the court and say, we need to waive the bond, or do you?
Actually,
not do anything?
yeah, you do. In your petition, you say no bond is required because there's, that's right, yeah, and the court says, okay, no bond. So I
So I
suppose,
think you can eliminate that last clause.
depending on what you do in the middle of the section. What have you got, Marissa?
Okay, so we're gonna say within 30 days,
Wait, start and begin.
okay. If the court issued letters to the personal representative, because subsection 1 of this section did not apply under subsection 2D, and assets later come into the possession or knowledge of the personal representative. Personal representative
Slow down.
shall, within 30 days after filing the inventory or supplemental inventory first showing assets of the estate, comply with the requirements of this section by filing a motion to set or waive the bond.
Or just file a motion to set or waive the bond as provided in this section.
Okay, so go back on this, comply with. That's fine.
Are we okay with that in concept?
Does that mean though that way back in 1, we should be saying something about filing a motion
But-
if we don't look there?
But that's what I said, I don't want to change that, because I know.
Inconsistent.
Well,
It's inconsistent already. I mean, I would almost stick something in here that says, file a bond to the clerk of the court in an amount set by the court. At least that ties it all together.
Who waives the bond because it's no assets? What's that?
11. Statement of the extent of assets, what waives the bond?
That waives the bond because it's no assets.
It's right there, D.
D, it's the new D on page 3.
It says subsection 1.
That's the waivers.
If,
So 3 should reference 2D.
It does.
Says under sub.
So it's what it comes because.
Third line.
Yeah, third line.
Okay, so if the court issued letters,
Right.
it's not right. If the bond,
What?
if no bond was, I don't know, it doesn't, why does it have the tie to the letters?
yeah, maybe.
If no bond was required because 2D applied,
That could work.
and assets are later discovered, then
Well, I guess,
2D doesn't apply.
well, it goes back, I guess, I mean, I'm not, I don't think it makes much difference. If you look at 1A, I mean, there it is. Except as provided in 2 to 4, the PR may not act, and letters may not be issued until the PR provides a bond. So I mean, so that language works, I think, in 3, if letters were issued because.
Well, they weren't issued because the bond was waived. They were issued. The operative act that you want to undo is the waiver of the bond is under D. The bond requirements don't apply. You
Yeah,
don't have to have a bond. So,
if no bond was required under subsection 2D,
yeah.
I think that works.
Okay,
And then you find assets, then 2D doesn't apply anymore.
Right.
And then you got to.
Back to 1.
With 1.
And Marissa, what you want to do in,
You want to add the motion with 30 days in order to
yeah,
do that.
and that'll stay in.
That's fine.
Yeah, that'll stay in. And Marissa, you want to go back to section 2, you really do want to fix that, don't you? Provides a bond to the clerk of the court in an amount set by the court? I mean, it's certainly presumed when you get to B, the amount of the bond set by the court under this subsection,
Yeah.
but it doesn't say, okay, I'm okay with that. So if we go back on section 2, page 2, 1A, and letters may not be issued to the PR unless the PR provides a bond to the clerk of the court in an amount set by the court.
Yeah. I think that ties that together better.
Well, yeah, I think you need to, recognize there can still be a waiver.
Oh, yes, right, it does. That's all, because it starts with except as provided. Okay.
Okay.
And the legislative history will show that we did not mean to make any change, that we are just clarifying practice there. All right, let's move on then. That's-
There's a numbering issue at the beginning of 1A. The original says, except as provided in subsections 2 to 4.
Yeah.
And we've added in paragraph 3.
Okay. Thankfully, I have somebody else who checks all of those for me, because
That's good.
that's not the first time that's
I like double checking.
You
Okay.
just invited all this. You said these changes were rough.
Yeah, I know, right?
Okay, let's move on. I think we've got that one figured out. What's the next one, Marissa? We're back on page 4.
Yeah, we were already there, now we're back there. So,
Okay.
instead of 30 days after discovering the assets, we now have after filing the inventory or supplemental inventory.
And we're taking out the as provided in both subsections A or paragraphs A and B. Okay, so this section, this is publication. 5A says, this section does not apply if the petition for appointment states that no assets of the estate are known to the petitioner and no assets of committed possession or knowledge. If the petition for appointment to PR states no assets are known and assets of the estate later committed possession or knowledge to PR, the personal representative shall, within 30 days after filing of the inventory, supplemental inventory, commence publication of notices to persons as provided in this section. I may be optimistic, but that sounds pretty straightforward.
And in general legislative convention, this section is sufficient to reference
The whole thing.
ORS 113-155.
Yep.
That's what it means.
Yeah. Yeah, the 1s and 2s are subsections and the A's and B's are paragraphs. Yeah. Okay? You learned something, Chris. All right, section 4, oh wait, I'm sorry, what, change.
So now, I think it's the next page. Yeah, section 5, no changes to section 4.
Okay,
Section 5, at the end of subsection 1, looks like a little change, within 30 days after, that's the date of receiving, I don't know why that was in there, within 30 days after receiving possession or knowledge of the assets.
what?
Does it not say that?
No. You're talking about the end of subsection 1 of 5?
Oh, I didn't change that.
You didn't change
That's what I was supposed to. Okay.
Okay.
So that's gonna say,
Of the
within 30 days of receiving possession or knowledge of the assets.
Just that was kind of vague.
Okay. And then,
I learned something new today, so now I have to file an inventory. No, that's not what we mean.
Same comment about the as provided.
Yeah,
yeah, I'm gonna take that out.
Yep.
So, and then this did say if the petition states no assets.
Right.
Now it's gonna say if
Right.
the inventory.
Yep, that's right.
Oh, I did change it in the second place, so.
Oh, yeah, that's right, there it is.
Yeah, right.
Yeah.
Okay.
All right, good.
Okay. Sorry, I have to go back and forth between my notes.
Yeah,
and-
no, you're doing great.
Okay, now we're moving on to page 7. In
Page 6, you'll take out the as provided in both subsections,
Yeah.
subparagraph, or paragraphs.
This is section 7.
What requires you to file the?
Don't we have a whole new,
Yeah, that's in subsection, that's in section 4.
yeah.
Okay, so we force the file inventory, and then this.
Right, and everything else triggers off of that.
Okay.
Yep.
So in 5B,
5, where are we, subsection, are we in section 6 now?
7.
7, okay, sorry, okay, 5B.
5B,
Taking out the as provided.
yeah. And then, kind of in the middle, a claim presented to the personal representative before the filing of the inventory or supplemental inventory first showing assets of the estate. That last part was
Right,
added.
okay,
Oh, because I put that in, but, it was in the wrong place.
okay.
So,
Let's take this section, but this was the subject of some conversation last time.
yeah.
So let's take, paragraph B, 5B. If the petition states no assets or property of the estate are known to PR and assets of the estate later come to possession, that's kind of become a rubric now. a claim presented to the PR before the filing of the inventory or supplemental inventory for showing assets of the estate shall be considered allowed as presented unless within 60 days after the filing of the inventory or supplemental inventory, the PR mails or delivers a notice of disallowance of the claim in whole or in part to the claimant, et cetera. So the gist of that is we're telling them that if it's a no asset case, you don't need to respond to claims. So you haven't responded to claims that have come in because it's a no asset case. Now you discover assets, and on discovery of assets, the 60 days to respond to those claims, the clock starts ticking. We good with that?
So why the attorney?
Is that from the other language? That's,
What attorney?
what attorney?
Oh. I don't know.
We're- I was gonna say, I'm sure that is, yeah.
Subsection 1.
Yep, there it is. So that's just paralleling existing language.
All right.
The PR shall file in the estate proceeding the claim as presented and a copy of the notice. Okay, yeah, right, that's just back to the regular process. Okay, good. Next.
Okay, so in section 9, when you move to close the estate, the motion has to state that the purpose for filing the petition has been accomplished. In the petition, you're gonna say why
Yep.
you.
We've exercised the power of appointment. Done.
Okay. All right. Now, this one we need to look closely at, I think. In section 10 on page 9,
Okay.
3.
All right.
So in C, we've added a copy of the last bank statement for any account owned by the estate. And then in D, instead of the amount of allowed and unpaid claims, we have a list of the unpaid claims that are allowed or disputed. I'm reading this from my notes.
Yeah.
Might be a little bit different, I'm not sure. And then in C, in paragraph C,
Small c.
yes. I changed this, but I wasn't sure what I was doing here.
All right, well, let's back up, because we had conversations about this section last time too. Let's go back to 3A. Unless otherwise provided by order or rule of the court, PR may file a statement under the subsection in lieu of the account required under 1A or B. And 1A or B is annual accounting and 30 days after the PR's resignation. So it's unless otherwise provided by rule, order or rule of the court. So a creditor or somebody
Oh,
or,
that was just come out.
pardon?
The rule.
Oh, that's right, yeah, that's right, rule of the court, thanks, yeah. Order of the court. Okay. This section, if the distributees consent in writing. Okay. The statement under this subsection must include the period of time covered by the statement, the total value of the money and property of the estate on hand at the beginning and ending of the period of time covered by the statement, a copy of the last bank or financial statement received before the accounting for any account owned by the estate.
I think financial might be better if it was account.
I think that's where I kind of paused there too, Ken, because financial statement, that's sort of like you're tallying up
Everything.
Statement or financial account.
a copy of the last bank or financial account statement.
Oh.
Since we're just talking about any account owned by the estate, could we not just say the last account statement? Because that would cover bank account statements, financial account statements,
I think I
statements
might
for
be
any other
confused
kind of
about what that
accounts
is,
we have
but-
going on.
I'm not sure what the word account by itself would mean.
I think it's good to have bank in there, because that tells you what we're talking about.
Okay, so let's try that. A copy of the last bank or financial account statement. I think that's helpful. received before the accounting.
What's a financial account?
Oh, if you've got, if you're invested, brokerage account, yeah.
Strictly speaking, that would include a credit union account statement because a credit union is not a
Oh.
bank.
That's true, yeah. Yeah, so I think it works.
Did you say any financial institution, a copy of the account statement of any financial?
Does financial institution have a meaning?
Yes.
It's a defined term in chapter
It is.
706,
I don't know
and
if
it includes both banks and and credit unions.
But does it include brokerage or, other investment accounts as well?
No, it does not.
Yeah. Yeah, so I think it may be too narrow.
Yeah.
Well, so let's leave it,
Moving on.
yeah.
And
She hit the gas. A copy of the last bank or financial account statement received before the accounting for any account owned by the
Is
estate.
that, are we meaning
I'm
each
just trying to
account?
figure out if any account owned by the estate is specific enough for us to know what we're talking about. Why is account statement not a better way to capture the statements we're talking about?
Yeah, that's a fair question.
Oh,
Either account is not specific enough in both places, or it's sufficiently broad in both places. I don't care which the answer is, I just want a consistent answer.
How about the last bank account or financial account statement received before the accounting for each account owned by the estate?
there you go. You can't stop yourself, can you?
How many words should we add to this?
So Chris, you're okay. So a copy of the last bank or financial account statement received. Well,
Bank or financial, I mean, I think now we know what account we're talking about. The addition of account was helpful
So
there.
it's a copy of the last statement for any bank or other financial
I think
account
financial
that
institution.
issues statements.
Yeah.
Yeah.
So what was that, Ken?
I'm kind of, maybe the best thing is to just take bank out of there and just say the last financial account statement received before the accounting for any financial account owned by the estate.
Okay.
I think that's, credit unions issue financial account statements.
Yeah.
Banks do, brokers do. I think that would
Okay.
catch everything.
And then, that's a good point. Why do we call out banks in particular if we mean other things? And it's not different, it's just one of the same set.
Right.
Yeah, that's right, yeah. A copy of the last financial account statement received before the accounting for, and then I think any account owned by the estate works.
Any account,
Yeah.
I mean, to me, any account sounds like you just have to give them one, and
I think
I would
each
do
is better.
each, if that's what we mean. But
Yeah.
I agree, because it does sound like just one.
So what are you saying, Gretchen?
for each.
For each.
You want each one, or just like a copy of the last, that was the one that came in, the very last was the one, just one account that I got. That's
Right.
the last one.
Okay,
Just the
for
last
each
one.
account. Okay, I think probably each account is good.
You don't
And I think I would use financial account there.
Yes.
Each financial
Yeah.
account.
That's what I mean.
So use financial in both places.
Yeah.
Yes.
Okay. A copy of the last financial account statement received before the accounting for any financial account owned by the estate.
Each financial account.
Each, yeah. Each financial account owned by the estate. Bingo. Moving on, as Marissa says.
Moving on.
A list of,
I would say most recent rather than last.
of those.
Recent? Yeah.
Okay.
Before
Oh
we
my
move
gosh,
on,
this would be the best
well,
provision.
before we move on from this section,
Oh,
I just have to re-express.
oh, I understand. We'll come back to the, let's finish this section, then we'll come back. D, a list of the unpaid claims that are allowed or disputed.
That was changed.
Okay,
And this is the updated language.
yeah,
That was changed from the amount of allowed and unpaid claims.
right. The list of the unpaid claims that are allowed or disputed, okay. A statement describing why the estate is not ready for final settlement and distribution, and a declaration under penalty of perjury or an unsworn declaration, Uniform Act, if the declarant is physically outside the boundaries of the state.
Does that include Puerto Rico? Sorry.
The United States must have a definition somewhere.
within our territorial boundaries. We have fun.
Yes, but not Guam.
Does chapter 174 define United States? It
Do
must.
you really wanna know?
I'll take a look.
No.
It doesn't?
Boundaries of the United States,
See,
190.
boundaries, the.
So 190, okay, 190.
Yeah,
No, that's just the one place, so that's not for this, but that one does include Puerto Rico.
Are you talking about 174, 100
Oh, I didn't find that.
That's
There
right.
is, United States includes territories,
Right,
outlying
yeah,
possessions,
174 has your definitions
and
that
the
apply.
District of Columbia.
Right, yeah, definitions that apply to all the statutes. So, okay, I thought we must have a definition of the United States.
So outlying territories, outlying possessions would include Puerto Rico, would also include,
Guam.
yeah.
Very good.
American Samoa.
Yeah.
So in C, the note I had said, okay, so it said you're gonna mail the copy of the statement to each creditor of the estate who has not received payment in full. And then the note said creditors whose claims have been disallowed and didn't challenge. And I came up with this, but I'm not
Upon
sure.
filing a statement of deception, the PR shall mail a copy of the statement to each creditor of the estate whose claim has not been paid in full and is allowed or disputed.
Is that right?
I think so.
Okay.
Do you even need that? Doesn't that cover the full universe of claims?
Maybe I wasn't supposed to change it at all. Maybe that was
Well,
just a note.
each creditor.
I mean, could it just say it hasn't been paid in full?
And is either allowed or disputed, so yes, that is all creditors.
Okay.
Creditors who
Well,
have not been paid in full.
That gets rid of any of our creditors who've been disallowed and didn't fight about it. That gets rid of all of our creditors who've been allowed and paid. These are just people who still have skin in this estate.
Uh-huh. Well, that's
seems like a
interesting. So if you say all
reasonable
creditors, is that specific enough? Does it help to exclude those creditors if we say who've been allowed?
We were trying to eliminate the burden of serving this on creditors who've been paid.
Right, right.
And creditors whose claims were disallowed and they did not
Fight it.
Yeah.
do something
Right.
to prove their claim.
And so I think actually this language, not been paid in full and is allowed or disputed, really helps that.
Mm-hmm.
Yeah, okay. I thought we were
Well, I did
talking about
something
else.
right. in
You did something right.
this lovely
You
draft.
you always do something right.
Wait, John is raising his hand.
Oh, John.
Why do we require a statement about unpaid creditors when we don't require that in an interim accounting?
Because in interim accounting, you're accounting for everything.
They never identify unpaid creditors.
But see, creditors now, if this is waiving all your information in lieu of final account, so if I'm a creditor and you've been pocketing all the money, I need to be able to speak up to say, no, I want him to file a full-on accounting, tell me why there's only $30 left in the state.
Well, I don't mind that. What I worry about is that when you go to close the estate, are we gonna have the courts asking about the unpaid creditors?
No, because it's not in the final accounting section.
But it's in this interim statement.
But in the final account, you're gonna say all
Right.
the taxes are paid, all the creditors
Yeah.
are paid, go
Right,
away.
you're gonna make that statement in the final.
Right.
Right.
That's required already. And here, you're not making that statement.
I'm just worried that somehow this might.
I don't think so.
cause the clerks to require receipts or something, and you're never gonna get that from an unpaid creditor.
Right. I think it's okay.
Right.
That's the end of this one.
Well, except I don't know. Do we really use language "move the court"? That's in the last sentence of C. A creditor entitled to notice in this paragraph, I would say we file a motion. Yeah. To require an account. All right. So now that we've got the language fixed, Jeff.
I think
Yeah.
I have expressed some of these concerns
Go ahead.
previously, and I since talked with Judge Tennyson, and she does not think this is a good or prudent idea. The unpaid claims was one of the issues. I mean, if you have unpaid creditors and you have beneficiaries that are essentially consenting, but they're part of the question of action, how is that helpful to anybody to really know what's going on? If you have these unpaid creditors, it's gonna put the burden on them to decide whether to move for a full accounting, right? And if they do, what standard would a judge be using to deny them a full accounting if they request it? So the cost savings here may not be as much as some people think. I mean, if you're trying to avoid the cost of doing a full accounting and you end up doing a statement and a full accounting anyway, based on a request of the creditor, then what do people think of this?
Why aren't we requiring any creditors that are left, because this is an annual accounting,
Right.
to consent to the short form? Then I know that you're gonna pay me, or
Practicalities probably. But let me, and Jeff, you raise a good question, and does this help? If instead of may file a motion to require, what if we just said that basically an account would be required on motion of a creditor? So there's really there's no level of proof that the creditor has to say why the accounting should be required. Just on motion of a creditor, the court shall require an accounting.
but you're putting the burden back on the
You
creditor.
are putting the burden on the creditor.
We already have, because they gotta find the accounting.
I'm sorry.
They don't get the accounting, they have to go get the accounting, so they already have it.
And interim accounting now.
Yeah.
Yeah, it's true.
You know, anything.
And they have to look at it, and
Making
then
their
they have
lives
to decide
easier.
that there's a problem, and then they have to bring an action, so they've already got burdens on them.
So here they're getting more notice than they would have gotten had we done an interim accounting.
But I don't have any information.
You've got starting balance and you've got ending balance, which tells you if there's money left to pay you.
Well, if you're a creditor, and you're listed, you're owed $100,000, and you're listed as unpaid.
Right.
And you see the statement that says, we got $2 million of assets, and $1.5 million of it is the mortgage. There's a lot of money there, you haven't gotten paid, but is it money you get? Where you got assets, you got the total value of assets, that's enough information for a creditor to figure out whether they're likely to get paid or not.
But if
So
after,
I don't know if that's true. If you are one of several unpaid creditors that have $100,000 claim, you don't know how much the other creditors are looking at. You just know that there may be 3 other creditors. So in some cases, those could be small, credit card debts or the electricity bill. And you as the $100,000 creditor think, I'm good here. Or it could be 3 other, a second, third, and a fourth mortgage or something. And then people are lending like that. I'm just, so you don't know what those other creditors.
Well, it's listed.
And does that just become,
Listed in the statement.
I'm gonna say, does that just become, we need to make a clearer statement regarding what we're listing when we're listing creditors? Because it just says a list of particular types of claims. It doesn't say what information I'm listing about those claims. Am I just saying claim from US Bank, claim from Chase, claim from Comcast? Or am I saying claim
Are you listing
for X amount of cash
name of creditor
or X amount of value?
Whether you dispute it or not.
whether you have priority? Because,
You
this
could have
is a year later.
Mm-hmm.
You should have figured out your creditors and contacted them. And it seems that if you want this, free and easy way to do it,
Okay.
that you need to have them consent. And if I'm, owed $100,000 and I say, sure, fine, but if you've got 15 other creditors, should you really be able to not disclose any information?
No, that's
How-
Consent from like PGE.
Or
But it's a
Yeah,
year later,
or-
you should have paid PGE.
Well, you might,
You're not gonna get a consent from a disputed creditor.
how about this? How
See that as
about,
leverage.
wait, okay, I'm trying to find the compromise here. How about this? The creditor doesn't have to file a motion. The creditor can require it just by sending notice to the PR. And that effectively is the other side of the consent coin. You don't have to consent ahead of time. We don't require that. But we're also not putting a creditor in the position of having to file a motion with the court and get it on the docket. Basically, if a creditor has an issue with this statement in lieu, annual statement in lieu, all they have to do is make a demand, send a demand on the PR to do an accounting. And the PR has to do an accounting.
But if there's no court filing, how do we prove that the demand did or did not get sent to the PR?
Well, same way in the claims, yeah, that's right, in the same way in the claims process, that all occurs. What?
I don't like that when you have a disputed claim, because, that becomes a weapon.
Well, but then I guess what that acknowledges is that this consent in lieu may not be appropriate is not gonna be appropriate in all the states. And that's something you have to decide.
Oh, the guy's disputed claim is getting resolved somehow. It's either gonna go to some determination or they got litigation.
Right.
So it's already handled.
But I'm trying to find a place where we get substantially what we're after in this statement in lieu of the annual accounting, but don't have the battle with the courts in front of the committee. And I guess that's where, and it is a compromise, which means it's not going to be entirely satisfactory to either side of this debate. But we give you the ability we give the PR the ability to file the statement in lieu of final account. We send notice, we send copies of it to the creditors. And if a creditor believes that there is some reason to require a full accounting, then the creditor, makes a demand on the PR, and the PR has to do it within. And that way, it's sort of getting consent after the fact by not objecting.
Don't we usually pay all the creditors anyway unless we're concerned about the solvency of the estate?
Unless it's disputed, yeah.
But by that time, the dispute should be in some sort of process,
Right.
You think what works? This works? Requiring the motion?
I know, I think just the way it is.
Well, that's what I mean. It would require,
Yeah.
the creditor would have to file a motion.
Because it's likely only gonna be a disputed claim.
But that, again, that should already be in process.
Yeah, right? So.
Because the creditor would have to have filed the claim within the time for filing. The PR would have to have disallowed it within the time, and the creditor would have to have then filed the proceeding. And that all is gonna happen within a year, right?
Well, it was a no asset estate, they found the assets,
Oh, that's a good point. Yeah, right. Okay, thanks, that's helpful. Then what about the just on motion of a creditor, so not requiring the creditor to prove anything? Because you're right, what do you prove? What do you have to show in order to require the accounting? So why bother with that? Why not just say on a motion of a creditor, you get an accounting?
And then, if that's implemented, an annual accounting is gonna look more like an 18-month accounting. Just from, in most of these circumstances, they're gonna file their annual statement, then the creditor has 30 days.
Right.
Then
Mm-hmm.
that comes in, and then it's,
Yep.
how long do they have to then file
Yeah,
their
right. 30 days.
accounting? 30
Oh.
days. So now we're looking at 16 months after appointment for the first one. Is like the earliest or the latest it could be due. And then we're gonna get 3 extension requests on that. Is that something creditors like?
I guess let's guess, how many creditors will object to these? Yeah, how many estates will you have creditor objections?
I guess part of my concern is this, because we're starting from the point that the personal representative has to account for everything.
Yeah.
So if you now have this exception that I don't have to account for anything.
For everything.
For anything. My 2 brothers and I decide that we're gonna take all the money and leave the creditors out, and we don't have to account. And they're the ones who have to chase it down. I mean,
Well, if you and your brother take the money and run, your statement's gonna show that. There's no assets, and you're not gonna have bank statements to back up the cash, so you're disclosing that the money's all gone. Without all you don't have all the detail about which particular check it was that you used to steal the money, but you disclose there's no assets there anymore.
But I think that goes to Jeff's point, then I chase it down and 2 years later, the creditors are saying, because, I mean, when somebody does something wrong in an estate, generally courts aren't instantaneous in their responses or their knowledge about what happened. Hold on, I'm not sure that's true anymore.
Kathy?
How about on really, where we have to say a statement why the estate is not ready for final settlement and distribution? And we also include why, or the plan for creditors, or, you know, if creditors have not been paid, why they haven't been paid. I mean, if we just put something addressing the creditors, and I think it doesn't have to be much.
That's fair.
We had that at one time,
Something
something like that.
That would be fine.
Yeah.
Or maybe you would put that in D,
If you're a year out and you haven't paid your creditors.
or no, that'd be a separate section.
It's fair to ask how come.
Right, because usually, like I said, it's only, you're kind of concerned about something.
Yeah.
So,
That whole conversation going on in the listserv right now about
yeah,
somebody doesn't want
Credit
to
cards.
sell the house to pay the
Oh,
creditors,
yeah.
who can live in there.
Yeah.
wait, let's go back to D then. Let's say a list of unpaid claims that are allowed to would,
Well, you know, that would be great to smoke that out like that.
back to D, a list of the unpaid claims that are allowed or disputed, including, we want the name of the creditor, the amount, and the, pardon?
The priority.
Priority, okay,
Oh, that's hard.
yeah.
This is a year later, why haven't you figured this out?
Priority under, and then we refer to the priority statute? Okay, I mean, that's fine. And we want the nature of the, if we have priority, I guess we don't really need the nature of the claim. Just the name of the creditor, the amount, and the priority under
Who's
150.
the nature? I would put the nature in there, because how are you gonna know the priority without the nature, and the court needs to be able to tie the two together, right?
The PR is sibling claim for care they provided to the decedent prior to.
Oh, right,
Then
right.
in front of.
right. So you've claimed a priority, but if you describe it, you may raise a question whether that priority is.
Final illness.
Okay, all right. So the name of the creditor, the amount, description of the claim, and priority under 115, whatever.
Okay.
Okay, all right. So all the creditors are gonna get that. And then we need a separate statement, I think. Or maybe put a statement describing why the estate is not ready for final settlement and distribution. No, maybe a separate statement. Why creditors have not been paid? Somebody was after that. What was it? Was that you, Kathy?
Yeah.
A reason the claim is not in place, see?
Yeah, you can actually include that in D.
You could. That's just the reason the claim has not been paid. All right. So, D.
If allowed.
Well, that might be disputed.
Disputed is the
Yeah.
reason why it hasn't been paid.
Right.
Yeah.
Okay, so D will be a list that includes the name of the creditor, the amount, the description of the claim, the priority of the claim under the statute, and the reason why the claim has not been paid. All right? We'll still, who knows? But I'm trying to make this at least work. Now, what about in C, to get to Jeff's point, if a creditor files a motion, what do they have to show? Do they really have to show anything other than that they want an accounting?
Do we want them to file a motion, or do we want them to file an objection?
Okay.
We object to
Yeah.
the lack of a real accounting.
I don't think that we.
End of document, file your accounting.
Yeah, I don't think that works, because we're not really filing a motion. So we're not filing a petition or motion.
No, that's
we're
true.
filing a substitution.
Yeah, you're not asking for something.
Yeah, you're not asking for relief.
Right.
What you do is the petitioner, the creditor has to file an initiating pleading, which would be a motion.
And I just think that basically, I mean, because I don't know what on earth we would say that a creditor has to establish in the motion. other than that they wanted accounting. So why not just say on motion of a creditor?
Got a creditor file an objection to an interim account.
Yeah,
But the accounting includes a request that the accounting be approved,
right,
so it is moving for something.
right, right.
Yeah, so.
I think the idea here is that this is not going to be requesting for itself to be approved.
Yeah, okay, all right, so,
Blaine, you're still sticking the creditor with, I mean, they have to pay a first appearance fee by filing motion. Why isn't this notification to the personal representative and?
okay, well, let's ask, okay, and I, that's where I was going before.
I don't know, I like it if they can go right to the court.
Well-
Personal representative, I object. If we're trying to provide protections for the creditor, the best way to do that is through the court. I mean, I appreciate, it is what it is. When you have to file, in the court, you have to.
Why don't we
nobody-
open both paths? They can notice the PR,
Yeah.
or they can file a motion with the court.
Well, but I mean, practically, can't they do that anyway if they know, if the notice is to the PR and the PR doesn't file the accounting, then they file a motion to compel. Or to remove, or whatever, for violation of the, yeah.
Their fiduciary duty.
That's
If I've asked for an accounting after one of these, and as a creditor attorney, I'm trying, I don't like the idea of the substitution, but I'm okay with it, and I think there's some decent protections in here, but if I have an issue and I make a request, I do like the request, because I think that would also help us shorten the period that an accounting would be.
I think you're right, because you take out that period of waiting for the order.
Yeah.
Yeah,
And then if they don't do it, I'm not just gonna file a motion to compel, I'm gonna file a remove. I mean, this is, we're gonna say in this statute, this is a mandatory obligation.
Right.
If you've received a request for an accounting and you don't file it, then
You're violating.
you're violating your,
Or you're
yeah,
violating your statutory obligation.
yeah.
That's really what.
So if I represent a creditor who has holds a disputed $2,000 claim,
Okay,
then the first thing I'm gonna do is send a letter to the PR's lawyer that says, hey, if you don't allow this claim, I'm gonna file a demand that you file an account. Now it's gonna cost the estate $5,000 to keep defending a $2,000.
well, but, this isn't gonna be appropriate in all cases.
That's unfair leverage.
Well,
Yeah, but or you could just file an accounting.
file an accounting, yeah.
You know?
That's what we do today, right, that's what we do today. Yeah, I don't know how to get around that, because,
Well, you don't give them that power.
well,
If they wanna go to court and object, and if they wanna go to court to try to explain why an accounting should be filed, then that's fine, but put the onus on the creditor, but to just give the creditor a weapon like that doesn't make any sense.
well, but I see this as something that really is useful in basically your simple estates, where you're not gonna have objections. And you don't have those kind of issues. We're gonna give you this to say, if you've got battles going on with creditors who are gonna use this as leverage, then just file the accounting.
You would have to anyway. I mean, I guess it's like, it's saving the creditor and you the time to just, like, let's just take care of it now, instead of me having to respond. If they file it in court, you're just gonna have to respond. So, one way or the other, you're gonna have to do
But
that.
that's not how people think. If you've gotta file an accounting no matter what, there's nothing you can do about it. But if now you don't have to file an accounting, and a creditor has the power to force you to do something you don't otherwise need to do, then the creditor imposes the cost.
But,
They'll have the power to require you to do that, it's just gonna make them take the extra step of going to court. They still have that power, I'm gonna file this with the court.
and the fact is, you're not being required to do anything more than you are already required to do in every estate anyway. I mean, there's not,
You've got a disputed claim.
Yeah.
You should be, you're a year out. You have a disputed claim and you haven't paid them. Why hasn't the disputed claim been heard?
well,
You're still in.
maybe it was filed as in the last case.
Yeah, then you shouldn't file an accounting anyway. Too bad, so sad.
Well, notice though, this is a change to 116, so it applies to full probate too.
Yes, oh, yes, absolutely.
And under full probate, prove a claim.
Right, that's right. Yeah, so that's why.
So it's a separate action is gonna have its own lifespan, so it
So-
could easily be a year out without having a resolution to the claim.
So
That's
I,
complex enough that I would think then at that point you would be filing
an accounting.
an accounting.
Yeah.
Because that's a complex.
Yeah, again, I see this, just like in the statement in lieu, you use it in the simple estates where it's appropriate. And if you've got estates with hinky creditors and disputes going on, this is probably not the vehicle.
And would it
Say that in
simplify the
the,
issue?
In the notes.
But this is for,
Yeah, it's really intended for more simple situations, and if you have someone that you know is gonna file an objection, a creditor on a dispute claim, for example, then you should use the ordinary process of manual accounting.
Chris?
Would it simplify the situation to just not allow one of these when there's a disputed creditor?
No,
Or a disputed
I
claim?
don't think so. I think you could be, you gotta make a judgment call at some point to whether this is appropriate. But, yes, I wouldn't disallow it, because it may be a $2,000 claim, and
I think we're overemphasizing the value of the interim accountant to the creditor.
but we're doing that because, because we're taking away the accounting. I mean,
Yeah.
so that sort of highlights what's in the accounting. Let's go with this. And we'll, and again, compromise, let's see if this gets us through.
I stand.
what did we?
Okay, so the creditor can require it, by filing, basically, making a demand on the PR.
Oh, okay, so creditor entitled to notice under this paragraph,
May deliver notice
yeah,
to the person who's requiring accounting, and the PR has to file within 30 days of the demand.
okay.
Jeff,
Yeah.
would Judge Tennyson, perhaps have her concerns assuaged by the first line of 3A, unless otherwise provided by order of the court?
Well, yeah,
I don't think so. I had a conversation with her about it, and I think just the very notion of waiving the annual accounting is something that she's willing to testify against.
let's see what she thinks with this change. Because to me, it's sort of, it's the equivalent of consent. If all you have to do is send a letter to the PR, says, hey, I got this, I want to see an accounting. To not send that letter is consent. So this gives the PR the opportunity to do that. We're not creating a huge, no more burden than if the PR were to send a request for consent ahead of time. All you gotta do is say no. Only here you do it after the fact. And in that case, then the PR has made a bad tactical choice because they thought they could use this in an estate that's not appropriate for it. I think that's a good compromise.
Practical difference is, I can refuse, if consent is required ahead of time,
Right.
my failure to engage is refusal of consent and prevents this from happening.
Yeah,
Whereas this is requiring an affirmative action.
A letter.
Too.
a letter.
And so the creditor has to do this within 30 days
Right.
of the notice
Right.
that they got from the,
Yeah.
right.
I don't think that's a huge burden.
In actuality, most of the states, the vast majority of them are closed after a year.
You mean within a year? Within a year,
Within a
yeah,
year.
right,
The
By
big,
verified statement.
right,
I mean, like,
right.
so,
7 to 10 months.
Yes, right, sure, right,
By verified statement, for 60 or 70.
right. So this applies to a narrower subset of estates to begin with.
the ones that are open more than a year are generally complicated.
Or,
They're gonna file an annual account, or there's gonna be some complicating factor
Yeah.
that, I don't know, can't get the house sold
Right,
because of blah, 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 and
Yeah.
this is what it is.
yeah,
This is gonna be very, very narrow, and I think we've narrowed it down even further, protecting creditors.
okay, good, the courts are in favor of it. All right, moving on. No, but I agree, I think we've accommodated interests here.
Catherine's concerns, but these are gonna be pretty narrow,
Yeah,
I think.
and it's, yeah, and tell her that John got beat down here. He went away with his tail between his legs. He didn't get what he wanted.
I did say I stood beaten down.
I know.
I did say I laid.
Oh, you lazy. Let's try that.
Actually, to the court, a lot of their objections happen, and then they don't hear conversation and the compromise and the solution. And they just become very focused on their original objection without recognizing
That we've
the
made changes.
reasons that we've reached a compromise. And so at some point, the court has to have some respect for the lawyers and former judges sitting on this committee.
Well,
I'm sorry.
put
but
that in the comments.
that's
There you
the
go.
reality.
Make a mark on that one.
All right, that aside, I would like to think that this really addresses everyone's interest. The burden on a creditor that this imposes is, hey, file your accounting. That's it. That's all, that's the only burden that it imposes. But in those simple, the vast majority of the states, you know, that don't have those kind of creditors or issues, of course, the vast majority are done before a year, but yeah, anyway, if it's appropriate, we've given lawyers a tool that will save money if they use it in the appropriate case.
Can I just ask a practical question on, big D and the 3D?
Yeah, without waiving your objections. Yeah.
Is this like an asset schedule we're contemplating, or is this just?
No, it's a total, right? Or is it an asset schedule?
Well, I'm just imagining where you have the decedent has 3 or 4 bank accounts and a house and a car.
Yeah,
And during the first year, they, I assume, close those accounts to start an estate account,
right,
sell the car, maybe.
Right,
Maybe
right.
they're still sitting on the house. Then we just get a number at the end that doesn't really match what your inventory is
Right.
starting with, right?
because the inventory total was 473,000, and you get a number here that says 397. Okay, so you don't know what those, you don't know what those assets are, but you know there's $397,000 in assets. But that, okay, so that's, okay, because you're right, the bank account statements are not necessarily gonna tie to the total value, because there are gonna be other assets besides the financial account statements. So do you need to list those assets?
And would it be more practical to have the same thing statewide to say an asset schedule? So attorney in, court in county A
Yeah,
is
right.
requiring something, or B, or C, or D. So it would be consistent, and attorneys would know what they.
No, I agree with that, because you're right, because without that, requiring the account statements really doesn't give you much. It says what cash is available, but it doesn't tell you what other assets you can deduce, I guess. So, okay, a list of assets and their current values.
Yeah.
And then, and at the beginning and ending stuff? Or-
Well, yeah, but I don't know why it needs to be getting, you got that.
Right.
The hard part is reconciling how you got from the beginning to the end.
Right, and that's what we're,
Schedule that we use.
Right.
is complicated.
So, yeah, so Marissa's asking a question on the total value of money, property, estate on hand. Well,
You got a description of the money and property of the estate and the value.
Description of the money.
a description and value, total value and description of the money and property on hand.
It's not a total value now, it's,
Yep.
it's an individualized value, right?
Yeah,
And, yeah.
yeah. But I think we do have to do beginning and end, because this might be a second annual accounting, which in that case, it wouldn't necessarily tie back to the inventory.
Well, but you'd have already done one.
Huh?
Did have a first one?
Right,
Or maybe you didn't, because everybody consented at that time.
yeah, right. So do we want the total value of the money on hand at the beginning and ending of the period, or just the ending of the period? Yeah, that's probably okay. Because you're right, it'll be the inventory the first year, and if it's the second year, you'll have the list at the end of the last, okay, that's right. Yeah, so you can compare that to last year's accounting, statement in lieu. All
I
right.
would probably include it in there because my experience is the court doesn't like to go look for it.
Well, this is really more for, the court's not gonna look at this. This is
For the inventory.
for creditors. This is for creditors. At the statement in lieu,
The court's not looking at this, yeah.
but they're not being asked to approve anything.
Well,
No, but they're gonna look at it.
Okay.
They're looking at it, what the hell's going on here?
Right. So, okay, so Kathy says, okay, so beginning, all you have to do then is just copy and paste what you put as your ending.
Right.
Yeah, okay, so it's no great burden. Okay, beginning and ending.
Okay.
Yeah, and that ties in, back to the unless otherwise provided by court order. If it looks weird, you start.
Yeah, right, okay, you're right.
And now you had 1,000,000 and 100,000 claims, and now you got 100,000 in assets.
All right.
150,000 claims.
I think we've got something, here that'll work. I'm gonna be optimistic that Judge Tennyson will say, damn good job, Jeff.
Or she'll issue a standing order
In
forbidding
rule of
me.
the court, I would predict there's gonna be SLRs that say.
No, we're not doing a rule.
We
We're
took
taking a
out-
rule out,
You're taking rule
because we don't
out.
want the statutes to be subservient to the rules.
So you'd say there can't be an SLR that says that it's in the form of an asset schedule?
Oh, I think you could, because that,
I predict that's what's gonna be.
wait. And, but, I mean, that becomes part of the statement in lieu. I don't see that as being inconsistent with this, because, yeah, that would be a rule that says this is what the statement should look like.
Well, this says by order or rule.
Yeah, we're taking out a rule. Because the unless there is, you can't file a statement in lieu. That's different than saying this is what the statement in lieu, this is what the schedule should look like. The schedule under, 3A, B should look like this. The rule, I think the court could do that by rule.
And that's what I think the inconsistencies are gonna be going from county to county.
Yeah,
Well,
we don't want that.
But if we say in B, the description and value of the money and property in the estate, does that?
Is your county gonna have an SLR that says it has to be in?
I don't know.
What would be your guess?
You want to do it, SLR, fine.
Yeah, right.
It's the policy.
Well, and just, my only point is the inconsistency between counties.
But if we say description and value, and then if you've got different counties requiring different forms, it's still the same information.
Okay.
Or do we just import whatever the description of an asset schedule is, this section, and
No,
that
that's
we're
getting
putting
too,
assets
that's getting too rule-ish. That's getting too,
What about saying it's in the same form as would appear in an inventory?
oh,
Now, inventory doesn't come out.
yeah. I think we just say description and value. And you do it. And if the court wants to be more particular,
What's on hand at the end.
yep, beginning and end,
That's fine.
yeah. Okay.
I don't see how you could have a rule that requires it.
No, that's right, yeah, well, you mean, that shows transactions. Okay, good job. What else,
That was
Marissa?
it for this.
Okay, all right, let's move on. Let's go to wrongful death. This one I think should be pretty clean, right? And then we'll finish with, oh. Marissa, what's new?
How about it rightfully done?
Oh, wait, did we ever find out from Brooks about his conversation with OTLA?
Never emailed me. I'll check.
So let's proceed on the assumption that we are still good with that. So let's go ahead, Marissa.
Okay, so, in section 2, right up front, we, just changed this around, so that it now says apply to wrongful death claims and states with personal injury claims, because I think before it said
Yes.
states with wrongful death.
Right.
So I just moved those around. So it looks like there's a change in 3. Was this,
Yes, this is what Brooks was,
if wrongful death claim, send a copy of the petition to beneficiaries 15 days of time to object. Is that in here?
yep.
Okay, that's what I changed.
Okay, let's look at 3, because that was this is Heather's amendment,
Oh, yeah, it's at the end.
that Brooks was going to take to the OTLA. We haven't heard that it blew up, so let's move forward with it. If the PR petition.
Sorry, just
Oh,
one second. So I am on the listserv, and I haven't seen anything there. Was he going to be presenting it to the listserv?
Oh, he was going to be talking to the legislative committee.
Okay, because I'm surprised that they don't have an issue with this. I know this is something that's been discussed. And I'm sorry I didn't get the conversation.
No, that's okay.
This was discussed earlier this month. I apologize. So I guess I'm a little hesitant to assume that this means that they don't have any issue with it, because I think that this is a real sticking point for them.
No, noted. And yeah, and I don't presume, you're right, I don't assume that Brooks's silence or failure to get back to us is consent. So you're not bound to agree with this.
I doubt he's done it, because we've been really busy on 1/11.
Okay. Well, let's take a look at it, kind of like the statement in lieu. We'll ask everyone to suspend disbelief, and let's just see if this works.
We're creating a new requirement that we get our personal injury settlements approved.
Just a second, let's go through the language. If the PR petitions for approval of a settlement of a wrongful death claim.
Well, I'm back up at section 3.1.
Oh, 3.1.
Notwithstanding.
Yes.
Blah, blah, blah.
Yeah.
Parties to a personal injury claim may not enter into a settlement agreement without the approval of the probate court.
It's a personal injury claim that involves a decedent.
Right.
It's defined, that's.
Right.
Is that,
I think that's been in here from the beginning, hasn't it?
yeah, that's not changed.
No.
Is that new?
I mean, other than by policy of various courts.
No, I mean from the beginning in terms of our work on this LC.
Yeah.
Shannon, are you still with us?
So our issue was.
Yeah,
Oh, go ahead, Shannon.
I don't think that section 1, the language has been changed since we've been working on it.
Yeah. So then it sort of came from you. Tell Chris why we want the court to approve personal injury claim settlements.
Well, it's just a common practice of the courts. I know that for the personal injury claim, it's not specifically required by case law or statute, but the courts all require that you do it. It's just for some reason it hasn't been codified into the statutes yet.
So why are we giving abuse of statutory power? Like, why are we authorizing the judges to be requiring us?
Well, what's the argument against it?
Well, because I think it's just good for the court to be able to see what this settlement is and whether it's being distributed appropriately. So I think as far as like best practice, it is good for the courts to be able to review this information before a settlement is entered into. It also gives, oh, sorry?
Go ahead. No, go ahead.
I just, as far as.
Wait, Shannon, go ahead.
Well, it gives them a chance to just, see how it's, I guess this is just for the approval of the settlement, but, it's changed a little bit, but now it looks like there's going to be time for objections for the beneficiaries to review and say, that's just for wrongful death. So right. I guess this is, for a personal injury claim, this is also probably the only chance for the heirs and devisees to say whether they approve of the settlement as well.
Yeah, I guess it seems to me the policy question is the same for PI, personal injury claim, as it is for wrongful death. Different beneficiaries maybe, but it's still the same policy argument. Heather, you were going to say?
The sole issue that was part of this conversation is the court has to approve it. That's current practice, and it's not the current law. So the second question was.
So you're agreeing with Shannon, that's happening.
Yeah, the second question was, could the PR ex parte go to the court and get approval? And it was our position that that is an improper act. It's not in compliance with the right to protect your property interests. But there's a court of appeals case that says the proceeds from a personal injury claim are not a property right. And I'm sorry, I can't pull that case right out of my memory, but we all agreed in our conversation that the court of appeals.
That was decided wrongly.
Had decided wrongly, because how could it not be? It might be created, their reasoning for the court was, it was created by statute, so it's not a property right. And so our position was, lots of things are created by statute, and just because it's created by statute doesn't mean they're not a property right. So it was the ex parte contact, the reality that it is a property right, and just clarifying what should be done. Brooks and Matt were saying, they think that that court of appeals case should have been successfully appealed to the Supreme Court, but
Instead, they've appealed it to us.
Yeah, it's money-based, how much can clients tolerate?
So, Chris, your objection on the PI claim is what?
That it's adding steps without a significant reason, but if everybody else thinks there's a reason for it,
I can't distinguish that from the wrongful death claim in terms of policy, and why we would require those. So, I mean, it makes sense to me if we're gonna require it in one, that you require it in the other. Again, recognizing that OTLA may have a different view on this, but let's, like, as with the, statement in lieu of annual account, let's just suspend that and see if this works.
it just makes settlement that much harder. You have to get an agreement, and then you have to get an agreement to wait while the court figures out what it wants to do.
You already have to do that, you already say when you're settling, you're subject to court approval.
Let's look at 3. If the PR petitions for approval of settlement of wrongful death claim, PR shall deliver a notice and a copy of the petition and declaration to each beneficiary unless the beneficiary has waived notice in writing. Wait, okay, this is only wrongful death. Wait a second.
I think that was
Yeah.
by design, right?
Okay, so, that's okay, that's right, all right. So you don't have to give notice to the beneficiaries, but you have to get court approval
In PI.
in PI. Okay, what we're doing?
And,
Who's that, Shannon?
it is Shannon, hi. So, for this section 3, I guess my concern is that I thought we were generally trying to not change common practice or the law, and currently case law does not require notice to the beneficiaries to approve the settlement because they have no interest in that settlement. They do, get to have notice of distribution and allocation and closing the estate, but this would be a change in the law, and like I said, I think it is going to be very unpopular with the trial attorneys. I think that, when we discussed this previously, this section 3, in previous meetings, we've always decided to not include this. So, I don't know, I just wanted to throw that out there. What was the conversation that happened earlier this month that resulted in it being added in? Do you recall by chance?
My recollection is, you're exactly right. At that meeting when we had Bonnie Richardson and you and Brooks on the phone, people were saying, you have to get court approval, but you don't have to give the beneficiaries notice. And so
Right.
in the chapter 111 work group, which Brooks and Nat are on, a couple other lawyers, we had this conversation about when we're requiring notice in 111, what do we require notice for? We would have had to specifically accept notice to beneficiaries of settlement of approval motion. That would have been an exception. That would have been one of the sole exceptions. Otherwise, when you communicate with the court and you ask the court for relief, 111 is saying you must notice the beneficiary or devotee. And so if we want to specifically carve out wrongful death, is the reasoning because you add complexity to settlement, which was the issue. But how can you say, I can file a motion, here, Judge Cobb, this is what I want the settlement to do, please prove it. I have all of this conversation and back and forth with the court, and the court approves it, and then we come to final account. How can that be an appropriate interaction? I mean, the horse is out of the barn, the judge already has formed an opinion that it's a reasonable settlement, and so where is the proper procedure for the protection of the beneficiary's rights? So that was the conversation we had in the 111 group. If the OTLA comes back and says, no way, you can have ex parte contact with the court, then we're gonna have to specifically exempt it from the notice provision, which.
Well,
I see the problem, given the beneficiaries trying to object like this, is that, so often they always think the case is worth $1 million, and it's not. So they're gonna object all the time when they think they don't get enough money.
I don't disagree.
Well, and I don't know that that I agree with that specifically, just because Section 2 says that yes, the probate code applies except as specifically provided in this section. So if we're only requiring notice for allocation and distribution, then I think that by omission that we are specifically providing that notice is not required for wrongful death claims when we're approving the settlement. And we could probably clarify that, I think, in this section 3. I don't think it needs to be carved out in section 111. And also, I mean, I think that the reason that the court decided to not require beneficiaries receive notice of the approval of settlement in prior cases is because they don't have a right in the settlement at that point, just of the estate or of distribution. And if and I think that that's common in these, you know, when you're administering an estate, you don't have to get approval and provide notice to the heirs for settling a large portion of your duties as a personal representative. And I don't see this as any different. I mean, we don't require PR to get court approval and provide notice for every action that they take in liquidating and administering the estate.
So as one of the beneficiaries of the wrongful death that I didn't receive notice of, what recourse do I have if, you know, it was actually settled for far, far less than what it should have been?
Well, they are receiving notice of appointment of the PR, and they're getting notified that, you know, it may impact your interest as a beneficiary. And then they're also getting notice of the actions that have been taken, and they have a right to, you know, take action specifically against the PR if it's not administered in the way that they deem appropriate.
But the judge's question, I guess, is the PR has signed a release, so you can't go back to the defendant, the culpable party here. So, and there's no bond. Or is there a bond by this point?
But if you're a beneficiary who wants notice, the original notice of the appointment of a PR specifically tells you pay your filing fee, file and send your request for notice, and then you get notice.
So then
This is
I
just
would
adding
get notice and have standing to object to the proposed settlement?
If you'd filed a request for notice, I would think so.
Right.
I don't think.
Right, but you're filing the request to approve this with the court.
Right, well, I think notice wasn't required. You probably wouldn't. Oh, sorry, this is Sharon. Did you want to say something first, Lane? Okay.
Go ahead.
I think if you do request for notice, if notice isn't required, then you probably wouldn't be notified of it. I think that the action the beneficiary can take is that the appointment of the PR, who's going to be the person in charge of you know, deciding what is an appropriate settlement to put before the court, that the appointment of the PR, you can request that someone else be named if you think that they aren't fit to make that decision.
Well, it's a pretty clear policy choice. The mechanics of it are easy. It's a policy choice whether to require consent, and you know, I don't know that it's it's not entirely the debate whether the Court of Appeals case was rightly decided. There's that, I suppose. But this is more a matter of, do we want to change the policy, regardless of what the appropriateness of the decision was? Do we think there's something here that should, you know, that we should require to protect the interests of these beneficiaries, notwithstanding the court decision? And I think last meeting, there was a fairly good consensus around the table among those who were here that we would do that. And I guess, I'm thinking in this case, we sort of, it's a modular statute, because you could take out 3 entirely. If it turns out that 3 becomes the poison pill, you can take out 3 and the rest of the statute works just fine without it. So I guess our question is, do we put this issue on the table in the bill and then have the discussion in front of the committee about notice? That's an important public policy decision. Yeah.
Shannon's point about, you know, you can object to the appointment of the PR. Appointments of PRs are ex parte.
Well, but you do have the opportunity.
You get a notice to heirs
Right.
and devotees, but in order to remove the PR is already appointed at that juncture. So you're stuck let's say you're the other sibling of the deceased parent. How are you gonna remove that person? You don't have cause yet, they haven't done anything wrong.
He's gonna do something
You're
bad.
not gonna know that they've done something stupid until the horse is entirely out of the barn and there's no bond, zero. So that's the public policy issue.
Okay, well, what I want to do for the purpose of today is leave section 3 in, and let's look at it and make sure that mechanically it works. Brooks said he was gonna take it to the legislative committee. So I think I want to avoid any final decision on it until we hear back from Brooks. But, you know, and I think I'm right, that section 3 could just be taken out in an amendment, and the statute still would work just fine, but we'd have that discussion in front of the committee about notice. So let's look.
An additional thing before we dig into the actual meat of 3, is there a reason why we're only requiring this notice for wrongful death and not personal injury?
Yeah, that's a good question, because I said before, the policy is the same.
I'm not advocating this, but as a, secretary,
Secretary?
I think that we had discussion that the difference was that for personal injury, they would have to file their final account in order to distribute those, whereas for the wrongful death, once they get approval, they pay those out. That may have been the distinction.
That was our discussion.
Yeah, that, I
That there's a
recall.
lot of
I think-
sections that fall.
Oh,
Okay. Shannon?
are we changing in here that, because typically we do have a filing for allocation and for distribution. Are we changing that we have to get approval and provide notice for allocation?
Are we talking PI or wrongful death?
Well, for both. Typically, it's for
Wrongful
both.
death. Wrongful death is apportionment,
We didn't change anything in chapter 30 there.
Right.
so in wrongful death, the apportionment statute still stands.
So I'm just thinking for apportionment and for distribution, that would typically be in front of the court, so they would get notice and a right to object to
Right.
apportionment and distribution.
Yeah, I think we decided that already is under chapter 30, and so we weren't going to incorporate restate it in this statute. So this is just about the initial settlement.
So yeah, I don't think that differentiates between a wrongful death and a personal injury claim.
Oh, say that again, Shannon, I'm sorry.
Oh, we were saying, should we treat wrongful death differently in section 3 than personal injury? And I don't think that, you know, requiring extra, you know, the 15 days notice and everything in section 3, that we should do that because we're just going to distribute out and not get approval from the court, because that there will still be that process.
Okay.
Unless I'm misunderstanding.
If it's so critical that notice be given before we do all the apportionment and other pieces with wrongful death, it's just, if we're lumping them together for 1 and 2, what suddenly makes this step of the process different for 3?
I think it should be both. If we're going to do it for both.
My recollection is what we talked about is that PRs settle contract claims. Like if the state is owed money and there's a promissory note that's $50,000 and you agree to accept $40,000. So they make settlements all the time, and there's assets and there's a bond. That's not always true. Sometimes in PI cases, you don't have a bond, but you know, that's what we were thinking about. In wrongful death, there's almost no recourse. In PI, there's more recourse. That's my recollection of the conversation.
But yeah, I can see arguments going both ways, because again, the recourse to the personal injury settlement, the recourse is still after the PR has signed the release and there's no more money in the well to go back to. That is the same issue. Kathy?
Well, we do have the, PI attorney who filed a statement saying that he had examined everything and he thought that this was a reasonable settlement.
But you have that in the wrongful death as well. So again, the question goes back to, yeah.
I Either notice both or notice neither.
So if we left section 3 out?
Yeah.
What would the law be?
The same as it is today, that no notice to beneficiaries
But you still have to get a judge to tell you.
of the settlement. They get notice of the distribution and the allocation, but not of the settlement. That's what you would have if we take 3 out.
Changing is that you have to give notice to the beneficiary.
Uh-huh. And the opportunity to object, and from the PI side, I think it's a huge change. Because the 15 beneficiaries, and they'll all have their own idea what this claim was worth.
Yeah, and it takes years for these cases, to be tried through, and to come to settlement a lot of the time. That's why it's nice to have the objection, just to say, okay, this personal representative, I feel like this can't objectively represent the beneficiary's interests, and have them removed. So then, going through the discovery and mediation, that it doesn't just all get thwarted at the probate level.
Yeah. And I guess you could turn the argument on its head and say no notice in wrongful death. Because as Heather says, in a probate estate, the PR already has the authority to compromise all sorts of claims without requiring approval of the beneficiaries. And so if that applies in the context of a PR's authority to settle a personal injury claim, because it is just another disputed asset, that's right, disputed claim, that's right, then why do we not regard the authority of the PR and the personal injury, why do we not accord them the same level of confidence as we do in personal and authority as we do in the probate cases? So that's really an argument for no notice.
Yeah, I mean, you can have the biggest asset of your estate, a contractual claim or a
It's true.
promissory note, and
Yep.
the court never sees it.
Yep.
And so that's why it's such a huge public policy question.
Yeah, well, and it's a policy question that obviously bleeds into more, as you talk about it that way, then, why require personal injury and not a compromise of any other kind of claim? So maybe we do just take 3 out, because it's injecting issues here that make us all kind of uncomfortable if we carry them to their logical extreme.
If there's a wrongful death claim that you're settling, you already have to give notice to the beneficiary.
No.
But you have to file a call for the apportionment, so they all get notice of here's how much we have, and here's your piece of the pie.
But that's after
Whatever you wanna object.
that's after the pie has been baked.
Right.
Right.
It's different in a way, because the wrongful death claim is the beneficiary's claim, but the PR is prosecuting it.
Oh, that's interesting.
So why, you've got,
Ooh.
you got a PR acting basically on behalf, because it's statutorily, it's the beneficiary's claim, it's not the estate's claim. But the PR is prosecuting it.
Perfect. There's why you give
It's
no.
unfair to me that the PR could settle the claim and not let the beneficiaries know.
It seems unfair to use the PR. Oh, wait, you mean in a wrongful death claim?
Yeah.
But not in a personal injury claim.
But again, I
This
don't
is
know.
Hampton.
Yeah.
Well, I still feel like, the personal representative has been appointed to represent the beneficiary's interests. They don't have an interest until, we're dealing with apportionment. And, the PR is still supposed to resolve that claim. I could see why that might be important to determine whether we're going to require notice for a wrongful death claim and not for a personal injury. But I would still advocate for no notice, just because it's really the personal representative is the one who's supposed to be advocating for the beneficiaries and determining what the best settlement is.
So Shannon,
Not all
let me ask this: if we go with the no notice route, and we have a case where a PR has settled through collusion or negligence or whatever, a PR has settled a claim for grossly under the value that it should have been settled, and now the beneficiaries don't discover that until we get to apportionment. Do the beneficiaries, do they stand in a position to have a malpractice claim against the PI attorney for the estate, on the claim?
Well, hopefully that would be caught by getting court approval.
And I agree with that, but in the rare case, does
they would have potentially a claim for malpractice, and I do think that if it was the PRs, malfeasance, that I think that they would have a claim against the PR specifically.
Yeah, I
don't know
guess
whether that's,
a PR is probably not gonna have insurance.
PR would have a claim against the
Possibly, unless the PR was in, was at fault, but,
Even if you had court approval of what you said?
well, maybe you didn't fully disclose or something like that, yeah. Well, okay,
Substantially investigate, because remember, our wrongful death beneficiaries are not necessarily heirs and deputies.
right,
They don't get notice about anything until apportionment,
Right.
if you are the wrong kind of wrongful death beneficiary.
well, you do send them notice of the appointment of the PR.
Not on the
Yeah.
wrongful death.
Yeah, you do, they're interested personally.
yeah, no, you do. Okay.
Wrongful death, the way it's currently drafted, they're not interested persons that get notice. Heirs and devotees goes to heirs and devotees.
And interest. I was just looking.
Not now.
Because we didn't incorporate additional parties to notice if it's a no asset wrongful death petition, even though you would need to know who those prospective beneficiaries could be, right?
Right.
That was an issue prior, oh,
Go ahead, Shannon.
sorry, I don't know if I could hear all of that, but I do agree that that used to be, that is an issue currently where beneficiaries aren't getting notice of the appointment because it may be different than who the heirs and devotees are. But I think that this statute does correct that and make sure that beneficiaries are receiving notice of the appointment.
Do you think it does? Oh, yeah, because that's in
Yeah.
section 5. That's in section 5.
The new statute.
Yeah, of the new, right. So, okay, folks, I guess, I'm sort of hearing the strength for notice, waning a little bit.
It doesn't, I'm still kind of stuck on this, on the wrongful death situation. It doesn't have to be a personal representative. I mean, the statute gives the claim.
Right,
The statute gives the claim to the family.
yes,
And chooses to give the personal representative
Right.
the authority to prosecute that claim for them. If you look at it like a trust, a trustee would have the power to settle everything.
yeah,
And if it's not a very good settlement, then the beneficiaries could sue for breach of fiduciary duty.
right,
So here, it's the PR makes a settlement, presents one side, presents the PR's side of that to the court.
To the court.
It gets approved.
Right.
Because there's no contrary,
right,
unless it's, on its face ridiculous.
Mhm.
And the court, has no way of knowing what the other side of the story is, because there's no objectors there, and it gets approved and the PR's absolved of liability. It doesn't seem right to me.
Well, the other issue, John, when you talk about comparing it to a trustee's duty, the trustee has the power to do, don't forget, in ORS 13710, 1A, you have a duty to keep the beneficiaries
informed,
advised
yeah.
of things that could materially affect their interest. So we are basically scooping out the obligation to keep beneficiaries in the loop in any way, giving trustees, the PR, the ability to ex parte communicate with the court, and then no bond, no nothing. So that's-
But let's go around, because again, that same argument could be made to require, approval for just about everything the PR does.
You're right.
And I'm uncomfortable with that as we talk about this sort of, again, leading to that logical end. Because the same arguments can apply to any kind of compromise or settlement that a PR makes of a disputed claim.
Right.
And-
You don't have the duty, as a PR, you don't necessarily have a statutory obligation to tell the heirs and devotees what's occurring, but the fiduciary duty of a PR is similar to the fiduciary duty of the trustee of
Right.
the express trust.
Right.
So I think that the PR has a fiduciary obligation, it's not a statutory obligation, to inform the beneficiaries of material facts that affect their interests. So if you're gonna settle a personal injury claim or a promissory note, you have an underlying fiduciary duty to keep them advised so they can protect their interests. Doesn't take the court's review, but I think that the fiduciary still has an obligation to keep the people who are interested.
Are you gonna give notice to every beneficiary, every estate that you do now of?
I think that the
Yeah,
obligation
Well,
exists.
this is the same issue that we took up on appeal in Wednesday's case, where court approval, is limited, should be limited to the effective court approval, which should be limited to the facts that are presented to the court. So when the PR presents one side of this story and gets it approved, you know, the beneficiaries should have, if they're not participants in the litigation, if they're not there in court to present their side of the story, their claims against the PR should be preserved. But I don't know what happens. Once you get court approval, you're.
Shannon?
Well, I do again think that, you know, the time to handle this is at the appointment of the personal representative if they feel like they can't sufficiently advocate for the interests of the beneficiaries. And what I've seen in the past is if someone's appointed, but there's a beneficiary who doesn't think they're going to advocate effectively, if they don't want to remove them, what they do is they become involved in the actual underlying litigation, hire their own attorney, stay apprised, attend mediation. And that's really the best, you know, time to you know, figure out whether the settlement is going to be sufficient or not, because, you know, there's so much that goes into achieving a settlement in these cases. To have it thwarted at the probate level, I think is rightfully discouraging for the trial attorneys.
And let me, you know, John, to your point, there's nothing in this statute that says that the court approval absolves the PR of responsibility for having failed to adequately inform the court.
But the discharge does.
The discharge does, but the discharge comes after allocation and distribution, so everything's on the table by that time.
So should it be expressly stated that it doesn't absolve them from, if you have a court order?
Well, we're in a probate. I mean, we're in a probate. So,
A wrongful death.
A wrongful death, you're in a probate proceeding.
So, yeah.
Yeah, so I don't know that we need to say that it doesn't, because what we're gonna say, assume, don't we file a motion at the end? Yeah, the discharge operates as a release. So that's, we already say that the discharge is what operates as a release.
Right, there's no final account.
No, this is on motion, you get to where you file a motion to close the estate, terminate after a wrongful death, after allocation and distribution, then you file your motion, and it's that motion that operates as the discharge, not the court approval of the settlement.
But you're telling me as a PR then, I get a court order saying this settlement is legit, and then I get sued for making a bad settlement, and suddenly the court told me I was fine, but now I'm having to pay out?
Now you're supposed,
Well,
that's what Clinton said, right?
Because that makes no sense.
no, not necessarily.
The point is you get to argue about the final account.
Yeah,
But
because
there's
I mean,
no final account here.
but there is a motion for discharge.
You can't argue about it there.
But yes, you can, because at that point, well, I guess, no. You've already, by the time you get the motion to discharge, you've had the distribution and the allocation, so everyone has agreed to take what they've got. So there's really no basis for.
The allocation, and they argue about how to allocate proceeds, I don't think you get to argue about how much the proceeds are.
Oh, I think you sure, at that point, if you think the PR has violated their fiduciary duty by settling this $1 million claim for $100,000, you bet you do.
How do you bring that claim in?
Yeah.
You're in a probate, you file a motion with the court?
For?
I don't know, just surcharge the PR or?
The PR gets the court approval, $1 million settlement, and then you go to court to argue, to debate how the $1 million is supposed to be shared, and the beneficiary say, well, it should have been $2 million.
Right.
How do you get that before the court? The court's already approved the $1 million.
On the basis of the information you provided to the court.
What, you want to vacate it?
reopen the tort, have the probate judge vacate the tort judge?
No, this is gonna be between the beneficiary and the PR, not between the estate and not between the PR and the tortfeasor. The tortfeasor got a release, and they're done. So this is an issue where PR, you screwed up. And the court,
No, I see that.
huh? Yeah,
No, I see what
You
you're
know,
Yeah.
you got, if the PR were a court-appointed guardian ad litem,
well,
then all this would make sense.
I mean, aren't they essentially?
No, they aren't. Somebody's position is appointed. It's not, the court doesn't select the
The court does appoint.
appoints,
Yeah.
but how come it's not appointed?
So where are we?
It might not be a court-appointed fiduciary, or a GAL, but it does have that declaration from the personal injury attorney who would, I mean, essentially have a global objective view of the reasonableness of the settlement.
So I get it that we're trying to be practical, and I suspect that Herberger or Waddleberger, whatever that case, I think that the Court of Appeals was trying to split the baby, trying to address the PI lawyer's concerns about how are you gonna get everybody on the same page in a timely manner to actually accomplish that.
Right.
I get that, that's very practical. But we have left our beneficiaries without, I think, a practical recourse. Yes, of course, we can object at allocations, but what's the practical recourse? Is it the suit against the lawyer for inappropriate settlement, that's the recourse?
I mean, if we're silent on it, they have whatever recourse they would have.
So I still think that the PR who has statutory duties similar to a trustee of an express trust, I think that regardless of what we do here, that fiduciary duty of 13710.
Be careful, because again, we don't require that. We don't expect that in all probates now.
It's a can of worms.
It is, and I don't think we want to go there.
Well,
Because then you're filing motions with the court for everything you're doing, because I've got to, these beneficiaries need to know,
You might not want to go there, but I think that's what the current law is.
well.
Why wouldn't it be? Why
But
isn't
isn't the
that
difference
what the
that
fiduciary
you
does?
have to file a final account
Yes,
in an estate?
yes.
And if
operates
you've
as-
made all these screw-ups, you've filed a final account, the burden is on you as the PR, and I get to sit there and just object as the heir. I mean, that's what happens in probate.
Yep.
And that's the danger of being a personal representative.
And the money it's just in the wrongful death. The money already may be out the door. There may not be anything there, by the time you get to the end. So you surcharge the PR or something like that. But it's not the same protection as giving them notice ahead of time.
And that all works. The probate system works in the personal injury claim context.
Because you account.
Yeah, you got a final account, the money goes to the estate, you got a PR, it all works, just another disputed claim.
Right.
In the wrongful death part, it's, you got kind of a, half horse, half donkey or something. It's not the estate's claim, you don't have a final account, it's not the PR acting on behalf of the estate, it's just fiction. It's this kind of arbitrary allocation of the authority to a PR in an estate that really isn't even an estate except for the purpose of the wrongful death claim. And the statute gives the claim to the beneficiaries, and the beneficiaries aren't, so much very representative. If somebody walks up and petitions to get a pension voluntarily, and they get appointed because they're not disqualified, and so all of a sudden they're in charge, and the rest of the beneficiaries are participating.
And there's no clear way, as in an estate, in a final account,
Right.
I can sit back in a final account and wait until my PR messes all the way up, and then I get to jump out of the weeds
Right,
and
you can
say,
fix it.
I object.
Yeah.
I don't see any clear way in a wrongful death. And, thinking if I had an objection to the settlement I approved in an apportionment,
No, I think at that point, it would be too late. You would have to raise the objection once you see the amount, before you take your money, because you're gonna have to sign a receipt for the
but it would
distribution.
be setting aside, if I'm the beneficiary who disagreed, where is it? And I think the question is, what do I file? To set a motion to set aside the approval of the settlement, or?
No,
You
you can't do that. You can't do that.
You can't.
Just like you can do it with a PI claim, a regular personal injury claim. You shouldn't be able to do.
But in a personal injury claim, I have a clear way to object at the time of the final count. This was not enough money, you should have gotten me more money.
And when you get surcharge, you object.
I get a surcharge you if you've screwed it up.
Okay,
So
so.
where do I do that in a wrongful?
Well, don't, yeah, don't,
That I have to set aside?
no, you don't set it aside. That money is gonna stay there, where you're gonna say before the distribution is made, you're gonna say, there should have been more money
Right.
in the pot.
My
And
objection to the apportionment, it is a separate petition for surcharge.
that's right, because you're distributing here $100,000. You should be distributing $1 million. And it's not gonna go back against the tortfeasor, because they've got the receipt, they've got the release. But it does leave open, a claim, because you still are in probate, so you still have the ability at that point to file a motion to surcharge the PR, I suppose, for settling for less than the value that it should have been settled for. PR says, hey, I got court approval. You say, yeah, but you didn't, there are facts here that you didn't present to the court. So your approval doesn't protect you. You're not discharged until you file your motion and get an order of discharge. So it's all still fair game. I didn't get notice ahead of time, but now I realize what you've done. You should have gotten me more money, and we're gonna argue about that before I agree to accept. And I think that happens, I think that's possible right now under the statute.
Lane, you could fix it by making it a real probate. And just, having the wrongful death proceeds go to the PR.
Oh, no, I don't want to do all that.
Well, I'm not saying I want to either.
Yeah, right.
But you could have the proceeds go to the PR can file a final accounting. And all that the statute, the wrongful death statute does is change the beneficiaries, who's entitled to it, and it just changes the distribution.
But in a wrongful death, the final accounting doesn't really mean anything, because the money has already been distributed by that point, and everybody has seen it.
That's where you have to change. And then you have a structure that will allow the beneficiaries to bring a surcharge action against the PR for having made a bad settlement.
The only case that I've ever, as a practice matter, had experience where things were bad was second wife, children from prior marriage, car accident, husband killed, second wife injured. Total insurance coverage, I think in this one it was $300,000, and the wife got allocated 200 of that settlement. That never came up in front of the probate court. That didn't appear because the PR, who was the surviving spouse, just said it's $100,000 due to other claims. That's all that's left in the policy. And so that's what the court heard. The court didn't hear, oh, it was, the surviving spouse who got $200,000. So, the horse out of the barn. And that's, I think we need to just let the legislature decide.
Well, I think this is Shannon, sorry. Is there someone else?
Nope, go ahead.
I think in that situation, that probably wouldn't have come up even if notice was required for approving the settlement, because probably all that was you put in front of the court is that there's a settlement for $100,000. Because it sounds like there was only one person who died. Is that what you were saying?
Yeah, there's only one person who died.
So I don't know if, I think that we could have had the same problem even if notice was required for approving that settlement potentially.
Shannon, help me out. Help me out in your experience. Let's say we don't have notice before the settlement, but now we're filing we're negotiating with the beneficiaries, or we're filing a motion with the court to approve the allocation. If a beneficiary at that point, now that they see how much money is in the pot, if they feel like the PR has settled the claim for less than its value, and they don't want to accept $25,000 because they think they should be getting $150,000. Right now, can a beneficiary file an objection at that point to the amount of the settlement, in the context of allocation and distribution? Can they object, not that they, obviously, we're not talking about going back against the tortfeasor or undoing the settlement, but can they say, make a claim against the PR or the PI lawyer, for having screwed up and settled this claim for pennies on the dollar? And I don't want to accept the money because.
Oh, sorry.
No, you got it.
Yes, I think that if there was actual, like, they were negligent, or there was like a clear case that they fell short of their duty, then I do think that there's a claim against them individually. I don't think you can undo the settlement. But I think that the way you have this set up, I agree with you, Lane, that this is in line with what we require for the duties of a PR, generally speaking. Like, if you're analogizing it to the sale of a house, we trust that the PR will be able to determine fair market value and sell it, and then the family's informed of what it was sold for in the final accounting. And yes, there's no final accounting here, but we do have the statement that we have to file to close that says what the damages were and accepted and recovered and how it was going to be distributed. So we do have the information that the beneficiaries would need, to object at that point. And I think that the declaration that the attorney for the personal injury or wrongful death claim has to file, that's sufficient to quote unquote determine the fair market value of the settlement itself. So personally, I do think that I agree with you, Lane, that this is more in line with what we require of personal representatives currently, not requiring notice.
One of the protections, so if you want to be, I want to be devil's advocate, because I really think it's such a good question, is I actually had a case where the court appointed me on its own motion as guardian ad litem for a minor child in a wrongful death case. And the issue was the PI attorney got court approval for the settlement, got court approval for his attorney fees, and then the minor child didn't find out anything about it until we came to allocation. And the issue in that case was the settlement for the proper amount, and were the attorney fees appropriate? And we retained an expert to relook at the settlement. It was probably $50,000 to $100,000 shy, but what was really wrong in that case is without trial, only with a settlement conference once, in a pretty slam dunk case, the attorney took a 50% contingency fee.
Whoa.
Yeah, whoa. So Jim Cartwright was my lawyer in that case, and the court vacated its order approving the attorney fees. And we decided not to object to the lack of the extra $50,000 to $100,000 because it was so uncertain, but things were certainly tainted. I mean, it didn't look right, and it's true, we did get those attorney fees back on a promissory note with a deed of trust on a lawyer's residence. But that's,
that's interesting. Oh.
Go ahead.
Oh, it's so hard on the phone. I apologize.
Yeah, no, you're doing well.
You could get the attorney's. The attorney fees are something that's required to be included in the declaration, and to me, that's always meant that it's requiring court approval as well. And I'm surprised that they were approved as part of the settlement approval process. I've always felt like the only thing that doesn't require notice is approval of the settlement, not necessarily approval of the attorney's fees for the underlying litigation.
Okay, I'm getting tired.
Yeah. Well, if we don't want to do the notice, maybe we provide a little more clarity on recourse.
In the comments.
Or maybe you're right, Lynn, maybe, I would advocate to leave 3 out, but then also I don't know if we can do this, but leave 3 out, but say that this has been something that's been discussed and it'd be a policy change. We have sample language if you do want to include this, but we do want to have a further discussion with the trial attorneys involved.
Yeah, let's leave it at that for now, because obviously, just hearing the conversation today, my sense how the conversation with the trial attorneys is going to go. Well, I mean, we're not done with it, so let's leave it there for now. Let's hear what Brooks brings back to us. But I sense some heavy weather here. Matt?
A related question. In section 7, are we waiving the obligation to provide notice to deputy designated persons of the petition for appointment? Hold on.
No, wait a second. Petition, notice is, let's see.
The information, the deputy.
Yeah.
Yeah,
And so-
that's section 6.
Section 6.
Yeah, information to beneficiaries and Department of Human Services.
Oh, that's a different, yeah, you're gonna have this notice instead.
Okay, I need to remember then how these relate, because section 7 is waiving information to heirs and devotees. Section 6 requires something separate.
Yeah, section 6, you're giving notice to beneficiaries, which is the defined term in a wrongful death claim.
Okay.
And we're saying that that is in lieu of your standard notice to heirs and devotees.
That makes sense.
Yeah.
We were talking about, the possibility that beneficiaries
Would-
had notice,
right.
but I didn't see where it was.
But they will get notice. Okay, so let's look at, let's finish up with this then. We're gonna leave section 3 basically as it is for now, for discussion purposes, but we're not done with that. Section 4, deferral of requirements, if the only asset is a PI claim.
So within the last version, we had the wrongful death in here too.
Yes.
So we took that out.
Right.
And it's somewhere else.
Yep, okay, so now we go to, these are statutes, sections that relate only to wrongful death. The petition for the PR appointment, any beneficiary, interested person or person nominated as PR, name of the will, may petition for appointment PR for the sole purpose of pursuing a claim for wrongful death. Except as provided in 4 through 7, a PR appointed in this section, and now, okay, this goes back to your responsibility, has all the duties of a PR, which includes the duties of the fiduciary duty, whatever that means today, with regard to every other asset, which I think is protective of the beneficiaries. In addition to the information required under 113.035, a petition under this section must include the following information: statement of the petitioner is filing the petition for the sole purpose of pursuing a wrongful death claim, names, relationship to the decedent, there is beneficiaries, and a statement of all reasonable efforts. Okay. So it is important, we are imposing expressly here all of the duties of a PR in a probate estate, except as expressly excluded in sections 4 through 7. Section 6, information to beneficiaries and Department of Human Services, et cetera. Pretty straightforward. Any change in this?
Nope.
Yeah. Section 7, waiver of requirements.
Oh, actually, in section 6, I'm sorry, I just took out the final account, it's just
Oh,
before
yeah.
the filing of the statement.
Yes,
in section
right,
7.
because we're not doing a final account.
Sorry. Should, that intro paragraph, except in sections 4 and 7,
You said 4, sure.
should we, well, and also, I didn't catch that point, but, shouldn't it also include 8, which is allowing them to close by a motion? Since otherwise they would, if they're obligated to do all the things that PR should do, they would have to do a final counting, but we want to say that that's a substitute, right?
What do you think?
I think we may have added a section.
Yeah, well, I did, but I added it after so that it wouldn't, conflict with that.
It says except as provided in section 4 and 7, not 4 through 7.
So 4 and 7, yeah.
Well,
Right.
anyway, in 7(1)(c), it says in lieu of final count.
Oh, yeah.
PR may file.
Yeah, okay, so that works.
the new section is
Is that,
8, and I put that after so that I wouldn't have to change, or maybe it's 9. It's one of the last ones because I didn't want to mess with them. So that should.
yeah, so
Well,
that, I
the
think
other
that works.
thing with that is 4 is talking about personal injury probate.
Oh,
And
okay.
this is a
Oh, yes,
wrongful death.
that 4
thing.
does need to come out.
Oh, you're right.
That fixes that change. So then now we just have 7. Do we want other things besides that?
Because 7 exempts the filing of the final account.
Hmm.
And then 8 describes what you do in lieu of the final account. So I think that works.
Okay.
In 7, we have the waiver requirements, information, areas of disease, publication, bond.
I think there are changes in here, but just let me.
Okay.
Change it in the right place.
I just have one change for section 7, 1C. A lot of times, the damages accepted and recovered the request for distribution is occurring at the same time as filing the statement. Is it possible to change the sentence to read, stating that damages accepted or recovered in the wrongful death claim shall be distributed as provided in ORS 30.030 instead of have been distributed?
I don't think so. This statement comes after it's all done, doesn't it?
It's not, maybe it's just a practice in our office. It's not uncommon for us to combine allocation, distribution, and the final account all in one document.
I don't know. It seems, especially where the effect, and we say in section 8, the effect is to discharge the personal representative, to discharge them on a statement that they're going to do something prospectively. I like the idea of this coming in after it's all been said and done. This is the last thing you do before you close the door and turn off the lights.
But I thought that section 8 is the last thing we do. That's we're moving to close the state.
Right. Yeah, I guess I see section 8 as sort of describing what C.
Yeah.
My guess is if our office continues to do it that way, this probably won't even be an issue.
Yeah, so Shannon, if you look at section 8, when a PR, it's 8.1, when a PR is, let me see, no, I see.
8.2.
I think we need a crosswalk between C and 7,
Okay.
7.1C and section 8, because I see section 8 as describing what you do instead of.
Yes, shouldn't C simply say in lieu of final account, you can file the motion described in section 8?
Right, that's what I'm saying, yeah.
Okay.
Oh, I see. Okay. All right.
Okay,
So
so
now this is going to me file a motion to close under.
section 8, yeah, that makes sense, yes.
Oh, the bond was also added in here?
Yep.
Yeah, okay.
When a PR, section 8, when a PR is appointed, no other assets have been discovered, PR may move to close the estate after resolution of the wrongful death claim and distribution of any funds recovered, but no earlier than 4 months after the latest date of delivery or mailing of the information. 2, the motion must state that no assets of the estate have been discovered, the wrongful death claim has been resolved, and damages accepted or recovered have been distributed
That's
as provided in ORS 30.030, that's good.
And then the only other change here was to take out the surety because we're already.
Right. But getting back to our conversation earlier, the PR shall set a time for filing objections to the motion to close, not less than 20 days for the time set. Here shall mail a copy of the motion to close. And the court grants the motion, get a general judgment discharging the PR, operates as a release of the PR for any further duties, and a bar to any action. There's where the discharge comes. Yeah, Shannon.
So just in the section 3, the reference to ORS 116.093, is that including the beneficiaries? This is going to be all distributed to beneficiaries, right? Is that 116.093? Is that just describing heirs and devotees? Let me just pull it up.
Yeah.
Current law, yes.
Yes.
Under the pending law, no.
Wait, But under 09, yeah, the 093 would pick up all your other heirs and devotees.
No, Shannon's right. It won't include beneficiaries.
Oh, you mean, wrongful death beneficiaries, right.
Right.
Shannon, the way we've got 111 drafted is it requires notice to quote-unquote interested persons. And so wrongful death beneficiaries would be the interested persons. But I don't know if we're gonna get 111 done in time to match this.
Yeah.
I see. Yeah, so
But-
maybe we should make sure that beneficiaries are included. Or, I mean, it seems like this whole section, we're just requiring notice to beneficiaries, not beneficiaries and heirs and devotees. So maybe just for consistency, we should.
Oh, go ahead. I'm trying to think though, the beneficiaries of the wrongful death claim have already received their distribution. So what was our thinking in terms of the 20, this is notice not to those beneficiaries, because they already have their money. There's nothing left. This is notice to the other estate, to your garden variety heirs and devotees. And it is because.
It's going to be kind of out of left field, because I don't think we've provided them with notice of the appointment or allocation or distribution, right? This is just going to be.
Yeah. Right, we have not provided them with notice, we've exempted that. So what are we doing here? Yeah, because you're right, the first thing you're gonna get, if you're a devotee and not a beneficiary under the wrongful death statute, the first thing you're gonna get about this estate is a motion to close.
Yeah.
Huh, that's weird. John,
I have some inconvenient observations.
what?
Want nothing to do with this bill, and I keep getting sucked in. Section 8,
Yes?
deals with what happens when when no other assets of the estate have been discovered.
Right.
It doesn't say what happens if other assets are discovered. Section 5 allows you to open a probate for the sole purpose of pursuing a wrongful death claim.
Right.
And one of the things I recall from having heard the experts' discussions is that sometimes you don't know if you got a personal injury claim or a wrongful death claim or both. So if you're in that situation, you can't open a probate under Section 5 because you've got a personal injury claim.
Right.
So what do? Is it a no asset estate, or do you have to do the full probate menu?
This would only apply if you know that it's a wrongful death case.
Well, but you don't know sometimes.
Well, then you,
If you don't know, you still have section 4, though,
Yeah.
that disperse some requirements of a full probate for.
well, personal
cases where
injury.
it's only a personal injury.
Yeah. But John raises a good point here. Do we need, since we're doing the no asset bill, since we got the no asset bill, do we need all of these provisions? Because a wrongful death would be a no asset probate, right?
That's right.
So,
I feel like we went through this already,
well,
but maybe not. Go ahead.
well, okay, yeah. So,
That wasn't the point, it was easy, but thank you for the credit.
so if you go back in section 5, I like that. Maybe what we do there is, we add a cross-reference to the no asset bill,
Well, we can't do that.
because it's not law.
Yeah.
How does that happen?
A conflict of interest.
Really? Yeah, because you're right, because this could get adopted and the other bill not get adopted. Oh, well, yeah, so you could do a conflict at the end.
Yeah, I mean, you probably want to avoid that. I mean, that's not really the best.
Well, because what we're saying is you can file.
You could put it in one bill.
So,
Yeah,
if you just go with a no asset approach.
Right.
And then section 4,
right,
which talks about personal injury claim, we just treat that as a no asset estate.
But a personal injury claim is not a no asset estate.
Well, you defer the bond requirements, you defer, you set that as, of course, a little manual account. So if all you got is a personal injury claim that has not been adjudicated or settled,
Right.
treat it as a no asset estate until such time as it.
Well, and we just.
No, because you're gonna file the inventory and say that you've got the, I mean, you're gonna do notice to the beneficiaries. And heirs and devotees. You're gonna publish. Yeah, I think it's better to call out these specific exceptions for that.
But if PI attorneys or litigators are looking at the statute, wouldn't it be better to have them look at the statute that says wrongful death?
Yeah.
As opposed to sending them over into something else and making it more complicated?
Yeah, and I just wish we could put, at the end of that first sentence, for the sole purpose of pursuing a claim, they can file a petition under, and then we refer to that other LC, so that, you know, it ties them together, it recognizes that we're talking about the same thing. But Marissa says, can't do that, and I understand that. So I guess that's fine. Yeah.
Not much power.
Not much power.
Not my power.
Enjoy it while you got it, right?
Okay, all right, well, let's just leave it with that then.
So.
Okay, what, Chris?
Also looking at that same introductory paragraph to section 8.
Yes.
It ties us to the doing of stuff under 113.145, which we explicitly waived in section 7.
Oh,
Okay.
no, that's a problem.
Yeah. All right,
Wait, because this is, so.
yeah, you're right, it is a
Yeah.
problem.
After doing a thing that we waived the requirement to do.
Shouldn't that say section 6?
Yes, that would be section 6,
Okay, yeah.
that's right. Okay, we need a December date.
So we have one, which is next Thursday.
Oh, okay, well,
That's
let's
been
go.
scheduled for a while.
All right,
December 6th here. Need one after that.
I think so.
Okay, I'll send out, now, the only reason there was not another one is because there was not a time that the key parties could get together, but I'll try again.
We'll do it, yeah,
I'll try again.
we gotta have it. All right, next Thursday, see you all, thanks, everybody. Bye-bye.
Thursday here, and then I'll send out some today.
So, Rob. Oh,
You know, this, I love that quality discussion, I mean, that's a dangerous discussion. It is. About how much